On the phone that just came in, CHR Manatee.
Yes.
What is your name, please?
Charlene Thurman.
What time is your hearing at?
8:30 a.m.
Do you have a case number?
Oh,
And you said the last name is Thurman?
yes. 212664.
Let me look it up. I see you in the computer, but I don't see you on the docket.
Yeah, because I think
Oh, a judgment by consent was entered. So did you handle this already?
yeah, it should have been handled, but I wasn't sure because everybody was
Yep.
acting like they wasn't communicating with me, and
Okay.
I didn't want to be in the wrong. So I swam here to make sure what's going on.
Yep, you are good. The consent
Okay.
judgment was entered, so you're good. You don't need to be here today, okay?
Okay, I just wanted to make sure because nobody was giving me answers.
Okay, well, sorry about that, but thank you.
Okay, thank you.
Yeah.
Bye-bye.
Bye-bye.
Good morning, Heather. I finally managed to
morning.
figure things out.
Well, good.
That was for what case was that for?
212664. It was already off the docket. She
Okay.
just didn't know.
Okay. Thank you for handling that.
Oh, you're welcome. I'm
If
making
you need me,
co-host.
holler. I'm going to mute.
Okay, thank you. Sandy?
Yep.
Can you look up 213668? I don't show it on the docket, but I have the attorney in the waiting room on that. Or an attorney, Edward Sala.
213668 for
Correct.
Bobby Lindsay.
Yes.
The only thing we have is a motion. We don't have anything else.
Okay, well, I'm gonna bring this guy in and see what he wants.
Okay. Yeah.
Hi, Mr. Sala.
Hello,
Hello, what are you here for today, please?
International Paint stripping.
What, do you have the case number? Because the case number that you have up there.
Oh, that's from my last Zoom last Friday. I apologize. I haven't had a chance to update it yet.
Thank you.
I had trouble finding where this was saved in my file, the link. So let me get you the case number.
Thank you.
Here we go. It is 2021 3580 GC. International
Oh.
Paint.
I don't see nothing with International Paint. Let me see. Unless it's more on here.
There's Cincinnati Insurance and CSX Transportation.
I'm sorry, our insurance is, yeah, it's subrogation. So we've already paid the claim. It's not on behalf of it. You're right. I just took over this file. So
Are you the defendant's attorney?
I represent Cincinnati.
Okay, thank you.
Okay. So you're in place of Jill?
Yes, that's
Okay,
correct.
thank you.
You should have received a substitution. I hope you did. They were supposed to send them out on all the files I took over. Let me take a look.
Are you from the same law firm?
Yeah, staff counsel.
Okay, so yeah.
Jill
We're
left
good
and I joined right after she left.
Mr. Neal,
Yes, good morning.
good morning. Are you here in place of Mr. Holzman?
I am the attorney on file for that. I filed the response and complaint, but yes, I'm here for Diversified.
Thank you.
I see on the 27th, we've submitted the order of substitution, but it wasn't entered yet for Cincinnati. So you should have that somewhere.
Sandy, I'm stepping away for a second.
Okay, thank you. We're all good with that substitution.
Okay.
Good morning. Appearances on Cincinnati Insurance versus CSX Transportation.
Good morning, Your Honor. Edward Salah for Cincinnati Insurance Company.
James Carnes for CSX Transportation.
Good morning, gentlemen.
Good morning.
Good morning, Judge.
So what do you fellas need from me? You need some discovery? You need motion dates? Where are we at?
I think we need discovery.
How long?
90 days.
90 days written discovery?
In
Everybody
dispositions,
thinking depths?
yes.
All right, Mr. Carnes, any objection to depths?
No. I'm just trying to think through if 90 days we'll be able to do both depths and written discovery, but no, I don't have any objection.
We can go to
If you want more time,
120.
just tell me. I have no problem with it. Want to go 120 to start?
I would go 120, yes.
Yes, I think that's a good idea.
All right, so let's just schedule another pretrial after that time period. Does that work?
Yes.
All right, anything else we can accomplish today?
I think that's all I needed, Your Honor. Thank you.
Nothing for me.
All right, have a great day, gentlemen.
Thank you.
Thank you.
Judge, next is going to be Diversified versus Austin. I just brought in Miss Austin.
Thank you. Good morning. Appearances for Diversified Members Credit Union versus Austin, please.
Good morning, Your Honor. Wesley on behalf of Diversified, P number 80307.
Good
morning.
Ms. Austin, you can hear us?
Yes, I can.
Thank you. All right, last time we met was September 21. All right, so today we've got plaintiff's motion for summary disposition of, correct, Mr. Neal?
That's correct, Your Honor.
All right, so Ms. Austin, I think we talked about this in September, but just in case, I'm going to explain. Diversified has filed a motion for, well, first of all, did you get the copy of this motion? We received it here at the court mid-November. Did you get a copy of a document labeled summary disposition motion or brief in support of?
Yes.
Okay.
Happy
I
New
do
Year.
not see, thank you. I do not see that you filed a written response, so I'm assuming you did not file a written response.
I didn't know. I apologize.
No,
I didn't know what to
I'm just
do.
making sure I'm not missing some documentation.
Okay. I
Okay.
did
All right,
nothing.
so a motion for summary disposition is, and Mr. Neal, if I oversimplify or misstate, correct me. Basically, Diversified is saying that in this case, with these facts, the law that applies entitles them to a judgment. If I agree with their assessment, then this case is going to be over today. I'll issue a judgment in Diversified's favor. If I deny their motion, if I don't agree with that argument, then we're going to move forward and we'll probably be setting a trial date. Do you understand the process where we're at?
Okay.
All right, Mr. Neal, would you agree with that assessment of where we're at today?
Yes, Your Honor, I think that's a fair assessment.
All right, so why don't you hit the high points of your motion, counsel, and then I'll give Ms. Austin a chance to respond.
Yes, Your Honor. Very simply, the court is aware of the procedural history on this, that we come to this matter via a motion to set aside, which we did not appear at the court's date for. The court granted that motion. The underlying facts are there was 2 loan agreements, a promissory note and a promissory note secured by a vehicle, both of which is signed by the defendant. Copies are attached. The vehicle was sold with the proceeds being applied to the outstanding balance. As of yet, we have not received any defense against liability in this action, anything substantive other than standard denials. As right now, the outstanding balance is $8,947.10 plus accumulated interest, court costs, and statutory attorney's fees. Again, there is no defense that has been listed as of yet to state why liability is not established against the defendant. Copies of the agreement as well as account statements are attached showing how the balance was calculated. Therefore, the defendant not having filed an answer or produced a defense, we ask the court grant our motion, enter judgment for the amount pled.
Thank you, counsel. All right, Ms. Austin, back in August, I told you to file an answer to this case. You didn't file an answer?
I thought I did. I found some paperwork. I brought it to the court.
Well, let's see what I got. All right, Mr. Neal, do you have a copy of the answer that was date stamped from the court August 16?
I have a answer dated, it looks like August 12th, 8/12/2021.
Yeah, okay. All right. Want to make sure you got that paperwork. All right, Miss Austin, go ahead. Your response to Mr. Neal's motion, please.
Well, Judge, I thought years ago this debt was written off as a loss by the credit union, and on my credit report, it indicated that it was written off. I was not aware that I still owed money. I'm not in the position now to pay anything. I'm retired and disabled. If I had known back then that they were still holding me accountable, I could have been in a better position to resolve this. The credit union did give me a loan for my vehicle, and I lost my job, so I didn't have no money to pay. And after so long, I spoke with the credit union, and I thought this was settled with them. And then a few years later, I get this documentation from this law office saying that it was still owing. So
Anything else, ma'am?
No, that's where I'm at right now. But I would like to get this resolved today if possible.
All right, Mr. Neal, anything else?
Nothing, Your Honor. I think the court has sufficient information to make a ruling.
All right. All right, I am going to grant the motion. I have not heard any dispute about any material facts or any other defense. Counsel, I don't think you submitted an order with the judgment. At least I don't see it with the paperwork.
I don't
Or
believe
order
so,
with the
Your Honor.
motion.
I can submit one directly today.
Yeah, why don't you do that? You can do that by email. And Miss Austin, if you want to have some conversation with Mr. Neal about maybe making some kind of a payment arrangement, I could put you in a breakout room so you two could have a private conversation today. Mr. Neal, you willing to do that?
Absolutely, Your Honor.
Ms.
Yes, Your
Austin,
Honor.
would you like to have that conversation with Mr. Neal?
Yes, I need to get this resolved.
Okay, all right. So in any event, I'm going to have Mr. Neal submit an order of judgment based on my decision on the motion. He'll submit that today. I'll sign it. We'll get it in the mail out to you and Mr. Neal. In the meantime, I'm going to let you have a breakout room conversation to see if maybe you can work out some payment plans. Do you have any questions, ma'am?
I do. If I had received documentation saying that this debt was resolved, how can they just still come after me later?
Because you just admitted that you had a debt and you never paid the debt.
Well, what was I?
The fact
I'm
that-
supposed.
Go ahead. Go ahead, man.
No, I'm just saying. True. The fact is, I had a debt, but the credit union said that they written it off.
All right, ma'am. Well, I made my decision.
Okay, I
You-
got.
you-
Okay, I hear what
you
you're
are
saying.
certainly within your rights to file an appeal. Would you
No.
like to have a breakout room with Mr. Neal?
That'll be fine.
All right. If we
Doing
can
it now,
make that
Judge.
happen, Heather.
Yep.
Thank you.
Thank you, Your Honor. You have a good day.
You as well. Heather, don't bring anybody else in yet. I got some paperwork I'm shuffling.
All right.
Oh, since that's one I just did. Oh, so that one I just signed the order, so that's all we got to do on that one. Yeah, I entered them both. Yeah. Hate these gray files.
Do you want me to go have Heather continue our way on both of them?
Probably don't need it. What, this?
Yeah.
Yeah.
And then I just took the attorney out of the system, so if you want to just cross the attorney out on the ROA.
That was Greenblatt, right?
Yep.
Yep. Okay.
Thank you, Judge.
Yep, thank you. Heather, do you have anybody ready?
Yep, next is Michigan Education versus Robinson. I'm bringing in Mr. Heron
Thank you.
and Grant Munson.
Good morning.
Good
Good
morning,
morning.
gentlemen. Appearances for Michigan Education versus Robinson.
Charles Haroon appearing on behalf of Michigan Educational Credit Union.
Grant Munson for the defendant.
All right, fellas, pretrial scheduled today, correct?
Yes.
All right, what would you like out of the court? Need some discovery?
Yes, please. We've exchanged a couple settlement offers at this point, and I think, yeah, if we could have 60 days for discovery, we'll probably get it wrapped up before the next time you see us.
That would be fine.
Written discovery, I assume?
Yeah, that's all I need.
Correct.
Shall I just schedule another pretrial?
Works for me.
Yes, please.
All right, that's easy enough. Anything else, fellas?
Nothing from defendant.
Nothing from
All
plaintiff.
right, enjoy your day.
All right, thank you. You too.
Thank you.
You're welcome.
Judge, I'm going to bring in Shirley Petway. I don't see her on the schedule and I can't figure out why she's here.
Thank you.
And this other person to figure out his name. On the phone titled John Scholl. What is your name, please?
Elizabeth Johnson.
Michigan Education Association file, Heather.
All right. I don't have the other party on there yet.
Ms. Johnson, we're going to put you back in the waiting room till we're ready for you.
Okay.
Shirley Petway, what are you here for, please?
Hi, I am here for, sorry. I am here for my pretrial conference.
What's your case number, please?
It is 491-975.
No, that's a Zoom number. What is your case number?
Oh, I'm sorry. It's 212-618. GC.
Heather, it looks like that one was dismissed on 12/28.
Okay. Ms. Petway, you don't need to be here today.
Okay, thank you.
Thank you. Have a good day.
You too. Bye-bye.
All right. And Ellen Seaborn, we're waiting for attorneys for the other party. Nothing else is scheduled till 9 a.m., Judge.
Thank you.
Yeah.
Yeah. My thing ain't still ain't showing though. My picture. It won't do it. Oh, I don't do it.
Hi, Zoom user, what's your name, please?
Benjamin Hill. Are you able to see my, not able to pull my,
Is there something
Picture.
that says to, for video?
it don't come up. I don't know why every time I do a Zoom meeting with you guys, it don't come up. Happened last time too.
All right, I'm gonna put you back in the breakout room until, the other party appears, okay?
Copy.
All right. Hmm. John, what is your whole name, please? John?
Got it.
John, what is your name, please?
John Day.
Oh, thank you. Let me rename you. All right, it'll be a few minutes. Mr. Hill, you are here for Elizabeth Smith.
Yes, for that office, yes.
Okay, thank you. So, Mr. Hill, you are on Seaborn and Gamble.
I'm here on one case, Midland Credit versus Eileen Seaborn.
Just that one. Okay, the other one's Midland Funding. Okay, thank you. Judge, I have her joining. She's not in yet, Miss Seaborn. It's Midland Credit versus Seaborn.
Still nobody from Michigan Education Association?
No. Well, I can bring in Benjamin Hill. We can do Mr. Day's case since Miss Seaborn's not connecting. Hill versus Summers.
Yep.
Morning, Your Honor.
Good morning, John. Good morning, Benjamin Hill. Are you connected?
Connected. I'm not, my pictures, my photo thing's not coming up.
All right. Today's the date and time set for a motion for summary disposition, correct, Mr. Day?
No, Your Honor, we had that the last time, which you denied because it turns out that Mr. Hill is in fact licensed in the state.
Oh, that's right. Thank you. So today's a pretrial.
Today's the second pretrial. I have had an opportunity to review the documents that Mr. Hill supplied to my client. And we're prepared to set this matter for trial unless the court would prefer us to try to go to mediation.
All right. You know, these types of cases are perfect for mediation in most cases.
I understand.
Mr. Hill, you willing to do that?
Yes, that's yes, that's fine.
All right. Hey, Sandy, are you listening?
Yes, Judge.
How are we doing that now? Are we sending the case to the mediators and they reach out to schedule, or are the parties scheduling?
If it's for my resolve, like my resolve mediation, Wayne County, then they will reach out.
Okay. All right. So let's make sure we've got good information for Mr. Hill. Mr. Hill, I've got your address at 24625 Heron River Drive.
Correct.
Phone number 775-0036.
That's our office. My personal number is 734-771-3526.
All right, so we'll pass that information on to the mediators and let them contact you folks to schedule. Understood?
Sounds good.
Anything else, gentlemen?
No, Your Honor. I will see you at 10.
All right. Good
All
luck.
right, you guys take care.
You too, Mr. Hill.
Thank you, Your Honor.
We do not have any other pairs yet, Your Honor.
Seaborn still can't connect.
She must have hung up, maybe.
Yeah, I don't see her.
So hopefully she's
And I don't
gonna
have-
try back.
I don't see a phone number in the file either. All right. Mr. Hill, bear with us. We're trying to get Ms. Seaborn connected.
Thank you.
Yes, sir. All right, good morning. Appearances for Michigan Education versus Johnson, please.
Yes, Susan Winters appearing on behalf of the plaintiff, Your Honor.
And Ms. Johnson, you can hear us?
Yeah, it's really hard to hear you.
All right, yeah, I've been having trouble with that lately, and I don't know what it is. I'll try to speak up a little bit more. All right, council, last time we spoke was in November, and my notes say we were going to do a motion from plaintiff. I don't see that it got filed.
Yeah, I believe that Mr. Cox was going to file a motion, but then the notes on my computer indicate that he was attempting to see what he could do about a resolution.
All right, so where are we at now? We're gonna set a trial date, or what are we gonna do?
Last I heard, when I spoke to Mr. Cox on the phone after the court Zoom, he said he was sending me paperwork to fill out, but I never received it. So that's all I know on my end.
And I do apologize, everybody. Mr. Cox has been kind of riddled with COVID issues. His son got it, his daughter then was exposed to it, and then Mr. Cox ended up coming down with it too. And he's missed a lot of work as a result, and I've been trying to cover things. So, and we've had half my staff out with COVID as well. So I'm not trying to use that as an excuse. It just has been very unexpected. So, because everybody was vaccinated.
If I adjourn this?
I'm sorry, say that again.
Do you have any objection if I adjourn this to give Mr. Cox a chance to get back on his feet?
Oh, no, that's fine.
And I do apologize
Council,
again. I'm not trying to use it as a crutch.
No, that's no problems at all. It's the world we live in. So how much time do you think we should adjourn this out, Ms. Winters?
I know that he had wanted to file a motion, and I can see through with getting that done and negotiate at the same time. So
okay,
if you could give us another 45 days, if that would be okay.
Sure. I'm making a note. We'll set it for at least 45 days out. Obviously, if you want a motion, you'll have to notice that up.
Yes.
Ms. Johnson, understood?
Yeah, so there will be I'll receive another court date for sometime after 45 days.
Correct. And in the meantime, you'll hear from either Ms. Winters or Mr. Cox about that settlement, the paperwork that you talked to Mr. Cox about, and or a motion.
Okay.
And let me ask you, Ms. Johnson, you're still at the Oak Lane apartment address?
Yes.
Okay. All right.
Have a good day,
I'll
ladies.
I'll be in touch with you. Okay.
Okay.
Thank
All right.
you.
Thank you.
All right. Bye, Your Honor. Thanks for your time.
Thank you, Ms.
Bye-bye.
Winters.
Thank you.
Mr. Hill, we seem to have lost Miss Seaborn. Are you okay sticking around for a while?
Yeah, I was hoping she would show up because we were going to investigate this for a potential hardship claim.
Yeah, we had her for a minute. We had her in a waiting room. We brought her into the meeting, couldn't get her audio connected, and then we lost her.
Okay,
So
I'll
she
stick
made an
around.
attempt. All right, thank you.
Thank you.
Good morning.
Nathan is trying to connect.
Thank you. Mr. Nathan, are you connected?
Yes, I am.
Good morning. Counsel, your appearance for Wells Fargo.
Good morning, Your Honor. Melissa Lingers on behalf of the plaintiff.
All right, Mr. Nathan, did you receive plaintiff's response?
Yes, I did, sir.
Court received it December 17th.
Yes, I did, Your Honor.
All right, so I've seen both your motion for installment payments and I've seen their response. Anything anyone wants to add?
Just for the record, Your Honor, to date, we have received a total of $2,682.62. That's 5 garnishment payments total so far. So the balance on the judgment remains $3,055.97. So those figures have changed since.
Your Honor, I have a total of.
Yes, sir.
Yes, I have a total of. I have a total of $3,600 and $11, I believe, that's been garnished from my check so far. probably 39, over 3,900 with this week. That's been
So
taken out.
Yep, it's possible we haven't received a couple payments yet, Mr. Nathan. It looks like the last one we received was January 7th for $604.36. So it sounds like there might be another $1,000 we're waiting on. You know, there's sometimes a delay and a lag from when the employer sends it to us.
39, it'll be 39, almost $4,000 by Friday.
Okay, so then if that's the case, your balance should be probably under 2,000 then at that time, once we receive those payments, Your Honor. But I have not received those. These are the figures I have currently received and posted from the employer. So I just wanted everyone to be aware that's where I stand accounting wise.
Well, I still out of my check. I can give you the figures right out of my check. Each deduction that had over the last 8 weeks, 9 weeks. I mean, it's been close to $4,000.
Completely understand. Like I said, sir, there is a delay usually in when the employer takes it from you and then mails it to us. So obviously you'll get credit for everything you've been garnished and we receive.
So Mr. Nathan, how often do you get paid? Are you paid weekly or bi-weekly?
Yes, Your Honor, weekly.
Weekly. And what have you been, what's the garnishment withholding been on average every pay?
Almost $550.
All right,
that seems about right, Your Honor.
All right, so in essence, the garnishment is paying plaintiff roughly $2,000 a month.
No, a little over that, Your Honor. It's been 7 weeks. It's been almost $4,000.
Yeah, but per month, it's roughly $2,000, roughly $5,000 a pay, or excuse me, $500 a pay, 4 pays in a month, so it's around $2,000. Would you agree?
Well, I know last month I paid like $3,000. Okay,
right.
yeah,
Motion's
yes,
denied. Your motion's denied, sir. Motion's denied. Have a good day.
Your Honor,
Thank you, Your Honor.
Your Honor, I don't understand why my motion denied.
You can appeal me, Mr. Nathan. You can appeal me. I've made my order. The garnishment's paying 10 times more than you're offering, so that's why it's denied. Have a nice day. Counsel, you got anything else with us?
Nope. Thank you, Your Honor. Have a great day.
You as well. What's up? Yeah, which one? Oh, give me a name.
I think it's like Eileen. I'm sorry.
Go ahead. You look.
Okay.
You look. I
Sorry,
do names,
Judge.
not numbers. That's all right.
Judge, we have Bellvilla versus Crawford.
Good morning, gentlemen. Your appearances.
Mr. Landau is still connecting.
Okay. Mr. Crawford, are you connected?
Yes, sir.
Good morning.
Morning. How are you?
Wonderful. Mm-hmm.
Judge, for lack of progress, does everybody usually come in, or I'm just asking because for Razor Capital is here, but Meriwether is not. Is that usually something that both parties appear on for lack of progress?
It's all over the board. Sometimes nobody shows up.
Okay.
You can bring the attorney in for Razor. Counsel, you're appearing for Razor Capital.
Good morning, Your Honor. Sam Cermak on behalf of Razor Capital.
Good morning. So counsel, we're on the no progress docket on this one. A review of the file shows that in May 2020, we did a Zoom pretrial. Plaintiff said, I'm just reading my notes. Plaintiff said case will be dismissed, set for in-house review 14 days out. Something must have happened because we talked again November 23rd, 21. My notes say plaintiff's motion to reinstate was withdrawn, set on the no progress docket for 30 days. I think, I'm going from memory, but I think at that point I was told there was some negotiations going on with the parties. So now here we are in January and we haven't heard anything. So what's going on?
Sure, Your Honor. That's correct. It looks like, so my notes had indicated that in November, we withdrew our request to enter judgment, and we did enter into a settlement agreement. However, that agreement was not honored. So at this time, we would like to proceed with judgment.
Well, I think I need you to set up for a motion for judgment so we can give Mr. Merriweather a heads up on what's going on, because at this point, he had no reason to believe that he had to be here today to stop a judgment.
Absolutely.
So go ahead and contact our civil department, pick your date, notice that up and get it out to Mr. Merriweather, then we'll go from there. Fair enough?
Thank you.
Awesome. Enjoy your day.
You too.
Are you calling Mr. Landau, Judge?
I'm trying.
Okay.
You have reached the law offices of Mark Landau. We are unable to take your call right now. Please leave the message after the tone and we will get back to you as soon as we can. Thank you.
Mr. Landau calling from the 34th District Court on Bellvilla versus Crawford. There you are.
Good morning, Your Honor. I apologize for my delay. I'm just finishing up in another court. Can you pass on the matter for the moment?
Sure.
Thank you so much.
You're welcome. Mr. Hill, still there?
Yes, sir.
Yeah, still haven't seen Miss Seaborn make another attempt. And as I said, we don't have a phone number for her, so I can't try to call her. What's your pleasure?
I was really hoping she would show up because based on her answer, it looked like this may be a hardship situation. We mailed out hardship documentation to her back on December 13th, and we haven't heard anything back from her. They've instructed me to ask for a default judgment.
All right. Do you have a phone number in your file, perhaps?
No, sir. I have no contact info at all.
Well, why don't we do this? Why don't you submit a default judgment under the 7-day rule?
Okay.
It gives her a chance to contact the court and let us know about her technical problems, whatever.
All right.
If that happens, then I can try to convince her to participate in the next pretrial because it might work to her benefit.
Sure.
All right. Does that make sense?
Makes sense to me. Well, we'll submit a default judgment under the 7-day rule. Hopefully she'll contact us.
Hope so. All right. Have a great day.
Thank you.
You're welcome. Mr. Crawford, bear with us. We're just waiting for Mr. Landau to wrap up with somebody else.
Okay.
Nobody else ready, Heather?
No, Judge. I'm going to bring in Miss Stritcherts and see what case she's on, because that case number we don't have it yet. Oh, she's not connected. 775.
I'm just giving you that back.
Susan,
Good morning.
good morning.
How
What
are
case?
you?
I'm fine. How are you?
I am good.
What case
let's
are
see.
you here on?
I'm here on Midland v. Gamble, and it's your 12-1775.
Oh, okay. Oh, you have 22. So I'm like, oh, that's a brand new case.
I have
Oh.
22.
Yeah, you have 22-1775.
Oh, I'm sorry.
It's okay. All right.
Jeez. I'm having a Monday on a Tuesday, I suppose.
All right.
So I saw the message about the long wait. How long, what kind of wait times do you think we're looking at?
That's just an average. I mean, that's just a something that they put in the waiting room.
Oh, okay.
But Miss
How's your
Gamble is not,
docket?
it's pretty full. People aren't showing up.
Oh, yeah, good.
Miss Gamble's not here yet.
Okay.
So we will just be waiting a few more minutes, okay?
Thank you so much.
Yep, thank you.
Yeah. Oh, no. Step out. And I know we're going to, the lawyer comes back and schedule a meeting, still want to get it talked out. We're going to give X amount of dollars. Can you take it? Okay. I just want to make sure we're on the same page where I got to get your. Well, yeah. That would be a given. Because again, this is ridiculous. So does the fact that we own the trailer. What did you read about this? A judge in Hamtramck raped a 70-year-old man over the coals because of his woman. I guess his property was in disarray outside, right? And she said, if I could, I'd put you in jail. This man's battling cancer. Needless to say, people all around her just like ripping this judge, demanding that she be moved from the bench. People bring it up. Well, you know that the judges are elected; they're not appointed.
Judge, my apologies for my delay, or courtroom, apologies for my delay. Lando here, I'm back.
All right, I'll let the judge know. Thank you.
Thank you. Can I maybe be put in a breakout room with Mr. Crawford and we
Sure.
can discuss our matter first?
Yep, sure. For the phone, for Elliot, your Deontay's the first name?
Dante.
Okay, thank you.
Ms. Strickard, which file are you on?
Oh, good morning, Judge. How are you today?
Good.
I've got Midland v. Gamble.
Gamble hasn't
Gamble
appeared
yet,
yet.
Heather?
No.
All right, not in yet, counsel.
Oh, okay.
Good morning, Mr. Elliott.
How you doing? I'm all right.
Wonderful. I'm going to try to give a call to the attorney's office. I don't know why we haven't heard from them yet, so I'm going to give them a last ditch effort to save this.
Sorry, Bob Turnett is not available. Record your message at the tone. When you are finished, hang up or press pound for more options.
34th District Court calling for Attorney Chernick on University of Michigan Credit Union versus Elliott. Case scam, it's 9:33. Case has been dismissed. Mr. Elliott, you got that?
Oh, case dismissed.
I'm sure they'll refile it, but at this point it's dismissed.
Oh, all right, sweet. Thank you.
Have a nice day.
You too.
Counsel, do you happen to have a phone number for Ms. Gamble? Anything in your file?
You're muted, Mr. Schertz.
Sorry about that. So we have a mobile phone number, but I think we're on a cease and desist. I can provide it to the court if you like.
Go ahead.
734-620-6843. And let me see on her objection if she put anything on there for a telephone. She's got 734-620-6843 on her objection, so I believe that is probably her most recent.
Good, let me try it.
Good morning, I'm with the court. I'll come see you.
Talk to your mom. We're gonna have to go out there.
Hello?
Rhonda Gamble, please.
Yes, that's me.
Ms. Gamble, I'm calling in from the 34th District Court. We've got a case scheduled, Midland Funding versus you. Are you ready for that?
Yes, I'm here.
All right, you want to get on Zoom?
I'm sorry, what?
Would you like to join us by Zoom or do you want to take care of it on the phone?
What's better?
Your choice. I need you to make a choice now though, ma'am. I'm running a docket.
I didn't think I looked at it.
I'll do it
What do you want me to do?
in the courtroom, right?
But at least we know we can put the
Your
trailer up.
options are we can continue with you on my speakerphone, or I can hang up and you can call in by Zoom and do it with video.
Okay, we'll do it. Yeah.
How are you gonna do it?
Yeah. Yeah, I'm sorry, they were talking.
Well, tell them to stop talking to you so you can talk to me.
Okay,
Now make a decision.
I'll do it by video.
All right, do you have the contact information so you can zoom in?
No, I don't.
That's on your notice. Remember the notice you got from the court?
On my phone, to zoom in.
All right, ma'am, we'll take care of it on the speakerphone. You filed objections to a garnishment from Midland Funding, correct?
Yes.
Plaintiffs filed a response to that. Did you see that?
Let me get the paper. Who am I talking to, by the way?
Judge Oakley.
Okay, I'm sorry, what's the last thing you said?
Oakley, Oakley.
Yes. Judge Oakley.
Ma'am, you're gonna have to tell that gentleman to be quiet.
Okay,
He's not on the file. He's not your attorney.
right.
The question I put to you was, did you receive a copy of plaintiff's response to your objections?
I received, a letter, of the Midland Funding.
Ms. Strickerts, would you like to hit the high points of plaintiff's response, please?
Yes, we believe that the defendant is trying to attack the underlying judgment through her allegations. We believe that that's improper under MCR 3.101 sub K. And we don't have any record of any proof of theft back in 2013. So we don't believe that there's any valid legal basis to find the state of Michigan garnishment invalid.
Ms. Gamble, can you hear the attorney for Midland when she speaks?
No, I can't.
Okay, ma'am,
Yes,
if I hear that man speak one more time, I'm gonna hang up the phone and I'm gonna enter an order against you. If you can't keep him quiet, pick up your phone and leave the room.
all right, he won't say nothing. Go ahead.
Plaintiff's response is basically that what you filed to attack this garnishment is insufficient. There are very specific reasons why you can object to a garnishment. For example, one of the reasons would be that the debt has already been paid. Another reason would be if the garnishment was seeking to take protected property from you. So for example, if you had a bank account and the only money in the bank account was your social security check,
Yes,
plaintiff could not garnish your social security money. Understood?
right.
So there are specific, very detailed reasons to object to a garnishment. What plaintiff just told me and what plaintiff said in their response that you said you received is that your reasons you listed on the objection do not fit any one of those specific reasons. It appears from your paperwork that what you're saying in objecting to the garnishment is you don't think you owe the money.
And they're also taking my income tax every year.
Okay, but that's not all right, I just heard the gentleman speak again. Ma'am, I deny your motion. I deny, ma'am,
There's people
ma'am,
in here talking.
I'm denying your motion. You filed objections to garnishment and you have not listed one of the reasons that you can object. Have a nice day.
Your Honor, is there a proposed order?
I don't think so. I'm looking right now. There is not. You can submit.
Do you want it under 7-day or email it over, or what's pleasing to the court?
You can email it.
What is the email you'd like it to go to?
Sandy will chat it to you.
Okay, thank you so much, Your Honor.
Have a nice day.
You too.
Heather, got anything? Mr. Landau, you ready?
Ready, Your Honor?
Mr. Crawford, you still with us?
I'm still here, sir.
All right, good morning again. Mr.
Good morning
Landau, I
to you.
think we've adjourned this a couple times just to see what the exterminator could do.
That is correct, Your Honor. There's bad news and good news. The bad news is that unfortunately, the exterminator at the last extermination made the determination that the roaches are still there and that the unit is not in a sufficient condition for his extermination to be effective. He did treat, but it's still not in a proper condition for it to be effective. So that's the bad news. The good news is that in the breakout room, Mr. Crawford and I have come to an agreement whereby he's agreeing to vacate the rental unit by February 18. And he's given me permission to add a signature to a consent judgment under those terms. And I did advise him of his rights to set aside the consent judgment and to appeal.
Okay, Mr. Crawford, you have any questions?
No, sir.
That's your agreement?
Yes, sir.
Okay.
Just make-
Excuse me. I'll
Your
wait for
Honor?
that. I'll wait. Yes, sir.
I just want to make sure that we are understood that because I own the trailer, I can't put this trailer up for sale.
That is a correct statement, Your Honor. I discussed that with Mr. Crawford in the breakout room. Under Michigan law, the owner of the mobile home has 90 days from the entry of the judgment in the termination of tenancy case in which to re-enter the property for purposes of selling the mobile home.
Understood, Mr. Crawford.
Understand?
Any other questions, sir?
No, sir.
Enjoy your day.
You too. Have a good
Thank you,
day.
Judge. Have a good day.
Thank you. Thank you. Hey, Heather, however you have me set up, I can't remove people from the meeting.
Oh, I'm sorry, Judge.
That's all right.
I knew you'd be a quick draw, so.
There we go. I got it. Hey, Joe.
Hey, Judge, we're ready to go on suites.
Sweets.
Yeah, it's a hearing, and we don't know if the other guy's gonna appear via Zoom. We're not sure.
Okay. All right. He's not here yet. You got anything else ready?
Nope, just two plaintiffs, no defendants yet.
He was supposed to be here. No, I think that's the reason I adjourned is because I told him I wanted him here. But I'm sorry, say that again, Heather.
We have two plaintiffs, 9:30, but no defendants yet.
All right, yeah, my note says plaintiff's gonna be here live and defendant maybe. All right, thanks, Heather.
Yeah.
When was that scheduled, Joe? What time was that scheduled? 10 o'clock, so they're early. Okay, all right, thank you. All right, thanks for letting us know. We got three people in here now, Holzman, Butler, and Schisler.
Holzman sounds like an attorney.
It is.
Okay.
You haven't talked to him yet? I'll find out what he's here
No,
for. Good morning, Mr. Holzman.
Good morning, Your Honor.
Which file are you calling in on?
Michigan Legacy versus Ranabarger.
We did something with that one this morning. I think there was a consent sent in or something.
There was.
Yeah, I've got it. I signed a consent judgment this morning.
All right, so no hearing will be taking place then?
Correct.
Thank you, sir. Have a great day.
You as well. That didn't do much good for us. All right, we're killing time now, huh?
you bring Menards in? Yeah, please.
Well, hold on a minute. That's what I thought. I don't have a file for them. I've only got one green file, that's small claims, that's Sweets. Heather, I don't have a file for Menards.
Hello?
Hey, court officers tell me that I've got a small claims case where everybody's here in Menards, but I don't have a file.
Okay, I'll find it and bring it right up, Judge.
Thanks. Wait for her to come through and then. Thanks. Yes. Oh, that's why. I'm looking for a green file. Thanks. We're ready, Heather. Well, hold on. She said it was removed, but I don't have that file either. Sandy just called and told me it's been removed, but I don't have the file on that either.
It was in there, Judge.
I'm looking. No, I don't have it, Sandy.
Okay, I'll look for it in.
Oh, no. I got it. I know.
Okay, good.
Menards is the
Phew.
defendant.
Okay.
Menards is the defendant. I'm looking for them in the first line. Yeah, bring it.
All right, thanks, Judge.
Thank you. Come on up, have a seat, gentlemen. And appearances for the record, Barber versus Menards.
Your Honor, John Day, 300 behalf of Mr. Barber.
Gary Green, Your Honor, on behalf of.
Thank you, gentlemen. Have a seat. You ready?
Yes, Your Honor, we are.
All right. Openings if you want them.
Briefly, Your Honor, my client went into the Menards store and purchased 2 gallons of custom mixed paint that was prepared by the Menards employee. The Menards employee allegedly secured the tops to the paint and gave them to my client's possession. He took them out, put them in his car. And then a few days later, he found that the 1 can of paint, the lid had not been properly secured, and contents of the gallon paint had spilled over the back seat of his Lexus, causing just under $4,000 worth of damage to the car.
Your Honor, oh, sure. Sorry. Your Honor, Menards discussed this matter with Mr. Barber when he came into the store a couple days after buying the paint. And as described by plaintiff's counsel, Mr. Barber did describe the fact that the paint was left in his car for a couple days. This was during a period of extreme heat, mid 80s, low 90s. The paint had obviously left the control of the defendant. Once it left the control of the defendant, then what happened from there, without direct proof from plaintiff of any negligence on behalf of Menards, at that point, it cannot be traced back to Menards, and therefore Menards does not believe it is liable for damages.
Okay. Ready for a witness?
Your Honor, plaintiff calls John Barber.
Mr. Barber, come on up. All the way up front here. Watch your step on this incline ramp over here. Okay. Raise your right hand for me. Swear or affirm, tell the truth, the whole truth, and nothing but the truth. Yes. Have a seat right there. Make yourself comfortable. Proceed, Mr. Day.
Just 1 second, Your Honor.
So showing Elizabeth Butler, Ajit Francis for Symphony Bank, and Scott Schizzler. Is Schizzler an attorney too? Yeah, so, okay.
State your name for the record.
John Barber,
And where do you reside?
Belleville, Michigan.
And did there come a time in May of 2021 that you purchased some paint at Menards?
Yes,
Which store did you purchase that at?
in Belleville.
And can you tell the court how that came about? What is you purchased exactly and how that transaction went?
Just simple. I was in the paint department and I bought 2 gallons of 2 gallons of paint, cement paint, and they mixed it. They put the cover on, both of them.
Let me clarify. You picked the paint, it was a custom color?
Yeah.
Push the mic down towards the podium and see if that helps. Thanks.
All right. You
push it my way. Call Fred, because there's some adjustments underneath you, I think. Go ahead.
Okay, sorry, Your Honor. Okay, so the color was a custom mix?
Yes.
So that required them to take the factory installed lid off and then put paint into it?
Yes.
And then what did they do after that?
They mixed it up and they put the covers back on the paint. But again, like I said, I don't think, obviously the covers weren't put on. One of the covers wasn't put on properly.
And then after that, you paid for the paint?
Yes.
You took the paint, where did you place the paint?
In my car.
What portion, what part of your car?
I believe it was the back.
Same with you. Push your mic away.
Gotcha.
Try that.
Yeah.
Let me show you what I'm going to propose that mark as Plans Exhibit A. Please tell the court what these are.
This is a picture of the back of my car, the carpeting that is not directly on the floor, but I believe is between the seat and the floor, the vertical portion of my car, the paint that's spilled.
Right. And the next picture.
Again, I think that's the same portion, just from a different angle. Oh no, it's the back seat of my car. Let's put it this way on the floor.
Thanks.
All right, and the third picture.
The third picture is the speaker that's on my door, the bottom of my door, with the paint spilled on.
Next picture.
That is a picture of the can of paint that the paint leaked out of, that I actually took a picture of when I returned it to Chris at Menards.
Okay. Did you take those pictures?
Yes, I did.
And do they accurately represent the damage to your car
Yes,
and the paint can in question?
yes.
Could you observe personally when you looked at the paint where it was leaking out?
You mean when I discovered it? Yes, yes.
And tell the court where that was.
Well, it was just on one side of the, just on the right side of the can where I kind of focused where the picture was. It was just on that side of the can.
And did you go to, okay, what kind of car do you drive?
A Lexus.
And did you go to a dealership to see about repairs for the paint damage to the car?
Yes,
And did you have an estimate prepared?
yes, I did.
Proposed exhibit B. Can you tell the court what that is?
This is just an estimate to replace the carpeting from Lead Mexus or Mead Mexus Lexus in Southfield.
And what is that amount?
390390.
And that's a combination of parts and labor?
Correct.
When you and I spoke the other day about this, we talked about the bill being rather high in terms of carpet. Can you explain to the court why the bill is that high?
Because they said that you just can't replace the portion of the carpet that is damaged. What you have to do is you have to take out all the seats and replace all of the carpet. And when you buy that carpet, it's just made to fit the whole interior of the car. So you have to replace the whole interior.
You know, if there's no objection, I'd like to move the admissions of exhibits A and B, the pictures in.
A and B are already on 1 and 2. Any objections, counsel?
No objection, Your Honor.
Thank you. Those will come in.
Did you report this damage to Menards?
Yes, I did.
And which Menards was that?
In Belleville.
Where you purchased paint?
Yeah.
And did they agree to reimburse you for the loss?
Well, they reimbursed me for the can of the paint that leaked out. They credited for that 1 gallon can for paint. But as far as damages go, Chris told me that their insurance company to go to the front desk and file a claim with their insurance company.
And then you were later told that they weren't going to honor your claim?
That is correct.
And because of that, you started this lawsuit as a small claims action?
Correct.
I don't know.
Any cross?
Good morning, Mr. Barber.
Hi.
My name is Gary Ream. I'm an attorney with Menards. Just asking a few questions this morning.
Can you speak loud, please, because the microphone's not pointed at you.
Sure. Mr. Barber, the day that you went to Menards to purchase the paint, do you recall what day that was?
I do not, sir.
Was it a Tuesday, a Wednesday? Any idea?
No.
Okay.
I mean, they obviously would have the receipts. I probably could have looked them up for the date.
So when you went back to the paint department, to the paint desk, you said that you watched them seal the paint cans, correct?
You know what, as far as do I remember them doing that? No, but I'm sure that they did, okay, because that's normal practice. They mixed up the paint, were very helpful, and I've bought lots of paint there, and nothing out of it wasn't anything out of the ordinary, but I don't remember them actually pounding the can.
You don't remember them pounding the can, but you know that that's normally what they do.
That's right.
Did he give you any ideas? Did Fred give you any ideas? Soldier on, Mr. Rain.
Yes, sir. After you got the cans of paint, did you place them in a shopping cart or did you carry them out? How did you get them out of the store?
You know what? The insurance lady asked me that question as well, and that was 2 weeks after. I don't remember if I carry them up my hand or put them in a cart.
Okay.
I just don't.
And was that all you purchased that day?
I don't remember that either.
Okay. So when you walked out of the store, you placed the cans in the backseat of your car, correct?
I believe so. Again, I don't remember that as well.
But that's where they were.
Yes.
And then presumably you then drove home or drove around town, or eventually you made your way home?
Eventually, sure.
Okay. But when you got home, the paint wasn't spilled at that time, correct?
I didn't look. I'm busy with everything, so the paint's in the back of the car.
Mr. Barber, excuse me, but try leaning back a little bit.
Or I could go back a
Yeah,
little bit.
try that.
Okay, so when you got home, you didn't look, so you don't know what the condition of the paint was at that time.
Not at that point, no.
Was there any smell of spilled paint in your car?
No.
But it was then a couple days later that you noticed that the paint had leaked out, correct?
Right.
Now, when you noticed the paint had leaked out, was the paint can on its side? Was it standing straight up?
I'm sure it was on its side because that's how.
Had you driven the car in between the time that you bought the paint and you noticed the paint had leaked out?
Yes.
When you noticed the paint had leaked out, the cover was still on it, correct? It wasn't
It
totally
was.
popped off.
Yeah, it was.
Then when you came back to Menards to report that the paint had leaked out, and you gave the can to Chris Schubert, do you remember that gentleman's name?
Yeah, I think that's
The
him.
gentleman right here.
That's Chris right there.
So the container was still in the same condition as when you had found it, correct?
Yes.
So when you talked to Mr. Schubert, he asked you a couple of questions and you informed him that, you know, the paint had been in your car for a couple of days and it had leaked out when you just noticed it, correct?
Yes.
And you told him that it had been in there for a couple of days, correct?
I did. Yes, it was.
And Mr. Schubert explained to you that it was probably due to the heat because it had been unusually warm at that time. Do you recall that?
He did. He didn't know, but that's exactly what he said.
Okay. And he said that the paint can probably expanded, or maybe the can expanded or the top expanded, and that's what caused the paint to leak out.
That's correct.
And then Mr. Schubert was the one that informed you to go to the front desk and report it to the insurance company.
Correct.
And then you went up front, you filed an insurance claim with Menards Insurance, correct?
Yes, yeah.
And then some days afterwards, you received a call from the insurance company for Menards?
Yeah, whatever it is, it's yes. I think I think you're self-insured. It was some other company that wasn't. They told me they weren't an insurance company, so I don't want to say that they were. She told me they weren't an insurance.
Yeah, to be specific, do you recall them saying they were a third-party administrator? Does that sound right?
That sounds correct.
But they interviewed you, asked you about the claim, correct?
They did.
All right. And you told the insurance representative or the third-party administrator as well that you had left the paint in the car for a couple of days and then it had leaked out, correct?
Correct.
I have no further questions.
Mr. Day, any redirect?
Just very briefly. When council asked you about the theory about the heat, that was what Chris told you. That's not what you're contending happened, is it?
No, it's not.
So when you answered yes to that, you were just saying that was a statement that was made to you by Chris, but you were not saying you were agreeing with his position as to what happened.
Right.
Mr. Reed?
No further questions.
Mr. Barber, you can step down. Watch your step. Mr. Day, any other witnesses?
Nothing further, Your Honor.
From the defense?
Defense is called Chris Schubert.
Watch your step on my ramp. Raise your right hand. Swear firm, tell the truth, the whole truth, nothing but the truth today?
Yes.
Have a seat. State your name, spell your last name, please.
Christopher Schubert, last name is Schupert.
Thank you.
Mr. Schubert, you currently work at Menards, correct?
Yes, sir.
In Belleville, Michigan? Yep. What's your position there?
Assistant General Manager.
How long have you been the assistant general manager there?
Since March.
And how long have you worked for Menards in general?
3 years.
All at the Belleville store or somewhere else before that?
Multiple stores. Move in every promotion I get.
Yeah, but at Belleville since March of last year?
Yes, sir.
And that entire time as an assistant general manager?
Yes, sir.
Obviously, you know why we're here today, correct? And do you recall having a conversation with Mr. Barber about the incident?
I do.
Do you recall when that took place?
The exact date, I do not. I know it was a Saturday because I was the general manager that day because I was the only one on duty.
And how did you come about having a conversation with Mr. Barber that day?
Mr. Barber came into our service desk. The service desk is not able to handle that situation, so they called for the general manager to come up. I came up to speak with Mr. Barber.
Give me just a minute.
Yeah.
Or should I get them? What time are you speaking? No need for them to come in. Just tell them what's going on. Yeah, I signed that their objections were invalid because she didn't show. No need for them to be on the record. Sorry about that, gentlemen.
So you were describing how you came to be involved in the conversation with Mr. Barber. Can you just kind of go over that again real quick?
Mr. Barber came in the store to our service desk where we do returns and warranties. The cashier at that point, not able to handle the situation. They called for the general manager to come up, and that's when I approached the service center to speak with Mr. Barber.
And when Mr. Barber came into the store, did he had the can of paint that had leaked, correct?
He had already brought it in, and it was sitting on the counter or the little stool where we do our returns at.
Okay. Did you have a chance to view the paint can?
I don't remember looking at it, no.
So when you had your discussion with Mr. Barber, if you could just generally describe what that conversation was.
So Mr. Barber explained to me what had happened, that there was paint leaked into his car. And I was asking him questions, trying to get a little bit more information if it had just happened, or if it was multiple days in a row. Mr. Barber said that he had been in there, he thought Wednesday, and bought the paint, and this was a Saturday. And I asked him if he had left it in his car the entire time. He said yes. And then I explained to him, I was like, with it being a thin aluminum metal, that with it being in the 90 degrees and probably over 100 degrees in the car, that the
Objection, lack of foundation, Your Honor.
I can.
Go ahead.
He's describing his conversation, but I can ask a more foundational question. So at that point in time, when you were describing your view of what possibly caused the paint can to leak, how did you come to the conclusion that it probably wasn't, or sorry, poorly worded question. What conclusion did you reach while speaking to Mr. Barber that was the cause of the paint leaking?
Objection, Your Honor. It's the ultimate fact of the case. It's not something he can testify to. It's an opinion.
Response?
Well, I think Mr. Barber gave his opinion as to why he thinks the paint can leaked, and so Mr. Schubert is just responding about the conversation he had and the opinion he gave Mr. Barber.
I'll allow him to explain his opinion.
So again, how did you arrive at your opinion that the paint can leaked because of the heat? I guess you could describe that.
Well, knowing our procedure and how we seal paint after we've mixed it, and the paint being in the car for 3 to 4 days, and with the temperature, that's how I came to that conclusion, that if you didn't notice it the first or second day, the heat, the reason I said that is because I assumed the heat caused the can to expand and caused the paint to come out.
And when you directed him to go to file an insurance claim, was that because you didn't believe him, or was that because that's simply the Menards procedure?
It's a Menards procedure. In my head, I did not think that we would honor that because it seemed like he was at fault, but it's just a procedure that we do, so I had to go up there and file it and let Gallagher Bassett make that decision.
And Gallagher Bassett is Menards' third-party administrator.
Yes, sir.
So in the end, you don't have any direct proof that the heat caused the
I
paint
do
to
not.
leak. But you had no other reason to believe that Menards caused it either, right?
Correct.
Have you yourself ever mixed paint at Menards or sealed any cans of paint?
Yes, I have.
Can you just briefly describe the procedure and how that works?
So when we're mixing color paint, the guest will bring what type of paint that they want up. They'll let us know what color they're wanting to use. Once we figure that out, we'll enter it into the system. We have to pop the lid off to mix the color into the paint. We use a rubber mallet. We hammer that back on. Then we have to put it in a shaker for 2 to 3 minutes, depending on what kind of paint it is. Once it's done shaking, we will pop the lid again, and we will take a sample and put it on top of the sticker that shows the color code, just to make sure that's the color the guest is wanting. And then we will, once again, take a rubber mallet and seal the lid. We don't have a necessarily amount of times we hit it on, but with that rubber mallet, we make sure, we do have a procedure to make sure that we go around the entire can.
I have no further questions, John.
Mr. Day?
Mr. Siebert, if I understood your testimony correctly, you have no idea what caused that paint can to leak. Is that correct?
That is correct.
You indicated the procedure that you use for paint. That's because of your familiarity with it. Is that correct?
Yes, sir.
Okay. The first thing they do is they remove the can, they remove the lid from the paint to apply the dye or whatever color they're putting into color the paint. Is that correct?
Yes.
Is this a metal can?
In this instance, yes, but we have plastic and metal.
Is it a metal top?
Yes.
When you take those lids off, don't you kind of bend the top a little bit as you're trying to get it? Because it's really tight. So you have to pry it off all the way around to get it to lift it up, pull it off. Is that correct?
With the tool that we use, I've never been away.
Not even slightly?
Not that I've noticed. I mean, there could be a micro bend, but not that I've noticed. No.
If I've removed a lot of paint, I've usually seen just a little bit of a tint after you pull the tops off.
Yeah, we use a tool that has a little hook.
Yes, I know. I've used that tool. All right, so then you put the paint back on, you use rubber mallet, you tap it all the way around. That sets that thing into the seal, is that correct?
Yes.
And then you do the shaking.
Yes.
And then you take the paint back out and someone removes a corner of the lid to get a sample of the paint, puts it on top to show the color, is that correct?
Yes.
And then they're supposed to tap it back around to make sure they got it.
That's correct.
Is it possible that someone, maybe in haste or in a hurry, might have missed one spot on the tamping?
It's always possible, but not likely.
But it is possible.
Yes, sir.
And that could cause the paint can to leak.
It could if it was not sealed.
I have nothing further.
No further questions.
So you can step down. Watch your step.
Your Honor, I have no further witnesses at this time.
Any rebuttal?
Nothing, Your Honor.
Ready for closings?
Your Honor, as I indicated, my client went in and purchased a can of paint from Menards. They basically made the mix. They were responsible for resealing the lid. My client took the paint back out, placed it in his car. Noticed later on the lid had leaked. The photographs show that there's only leakage from one side. We believe our theory of the case, Your Honor, would be that in the process of testing the paint color after it was mixed, that the person did not reseal the lid properly, which caused the paint leak in Mr. Barber's car, resulting in the damages that you see in the pictures and process and that has been supplied by Lexus. We're asking for damages in the wrong state on the invoice.
Give the exhibits. Go ahead, Thompson.
Your Honor, there's obviously two competing theories here. Mr. Barber's theory that the top of the paint can was not sealed properly. Menard's theory that the paint was in the car for a couple days. It was outside of the exclusive control of the defendant at that time. It's unknown what happened to that paint can while it was in the car for those 2 or 3 days. And at that point, because it was outside of the defendant's control, Menards could not be found to be either the cause in fact or proximate cause of this paint leaking out. Had the paint spilled on the way home from Menards right away to his house, I'd say we might have a different story here. We might not be here today. However, the fact that the can sat in the car for multiple days in 90-degree heat, I think Mr. Schupert's theory of the can expanding and the paint leaking out is just as valid as Mr. Barber's theory. And if the paint lid was still on the can, as Mr. Barber testified, then the lid to the paint can didn't just pop off and the paint spilled all over, which would then, I think, tend to Mr. Barber's theory more. Here, it just leaked out. And I think that tends to our theory of the can expanding and the paint leaking out, having been in the car for several days. And I think that, obviously Mr. Barber has some circumstantial evidence, but that's subject to a reasonable inference. It can't just be mere conjecture. And I think on the plaintiff's side, that's what you have here. You have conjecture. He testified he doesn't know, he doesn't remember, he's not sure. Whereas we have Mr. Schubert testifying that they have a system that they go through each time when they seal these cans of paint. So I don't think that the plaintiff has any direct evidence of negligence, and I don't think that they have raised any reasonable inference of negligence because of the facts of this case. And I think therefore the defendant cannot be held liable for negligence.
Mr. Day.
The defense has offered a theory with no factual support. They have offered a theory that it was hot. They have not provided anything that says what the temperatures were during the time of the question. On cross-examination, Mr. Schubert agreed he had no idea what caused the paint to leak. And he did admit after my cross-examination that it was possible that he didn't reseal it after they had tested the paint. That would be enough to leave a small gap in the seal underneath it, that when the paint laid over, it leaked out. It should not leak out if it's properly sealed. There can be probably no other explanation. Keep in mind, this is not a criminal case. I do not have to prove my case beyond a reasonable doubt by preponderance. And at least we have presented a plausible explanation of what happened. They have admitted that our theory would result in the leaking and could have possibly occurred. We have nothing to support their theory of heat expansion or any of these kinds of things. And he admitted that he never witnessed the paint being put on, paint lid being hit on. He doesn't know the temperatures of those days. This is just a theory he popped up when someone came in and said, hey, you damaged my car, so you can believe why his company's not responsible. I believe we've got our burden of proof in this case, Your Honor. I'm asking for a.
Thank you. I'd like to ask a question, and I'll let you fellows reopen proofs if you want to after I ask a question or two. Sir, have you ever worked in the paint department in your years with Menards?
I've only been trained over there, and then as of
Okay,
over there constantly.
okay. But you've been with the company 3 years?
3 years.
Okay. Have you ever known a paint can to leak while it was on the shaker?
On the shaker?
Correct.
Yes, sir.
Okay. What would cause that?
The seal not being, the can not being, the lid not being sealed back onto the can.
And I'm assuming the same process is used every time a can is resealed, i.e. the rubber mallet?
Yes, sir.
All right. Thank you. Gentlemen, any questions for either one of the witnesses based on my reopening the proofs on my own?
Nothing further, Your Honor.
Questions?
No question. Your Honor.
Okay. All right. Well, people, I'm like Mr. Day. I've opened and closed a lot of cans of paint. And I know this, even cans that are not properly sealed don't leak unless they're laid over. If they're upright, the paint doesn't jump out on its own. So Mr. Barber, I think your theory of the case is plausible, but had the can remained upright, you still wouldn't have had the problem in the car. So in essence, what I'm finding is that both parties bear a responsibility here, which gives me the ability to do what I always love to do, which is split the baby. So I'm ordering $1,500. I'll cut it right in half. Mr. Day is going to prepare a judgment in plaintiff's favor for $1,950. Any clarification necessary, gentlemen?
No, Your Honor. I will submit it over for the court.
Gentlemen, enjoy your day.
Thank you, Your Honor.
Thank you, Your Honor.
By the way, Your Honor, are you still entertaining venue changes back to courtroom 1 in the old building?
No. We'll fix this. He's good enough to fix this.
Beautiful building, Your Honor. Thank you.
Have a good day, folks. You want to play around with it?
Yeah.
Well, you get anybody ready on any of these bodies?
Yeah, well, don't you have,
Yeah, let's fix this.
Stevens is in the waiting room. And he's in the, yeah.
Yeah, let's see if we can fix this because we're gonna put the plaintiff on that one. No, nothing?
Nothing.
Nothing.
Because I mean, it was echoing throughout the whole thing. It sounded like a siren.
And both of them initially, I had them do this and it worked, and then it didn't work.
Yeah, it kept coming through.
Hello. It's like most of our problems. Fred.
Yeah, it was just these two mics that
Yeah,
every time somebody spoke.
And we can't get it to recreate when Fred's here.
What I did was, I
I
thought
saw
this
you.
was pointing towards one of the speakers, which would do that, so I took that down. Beyond that, that's the only thing I really changed.
I don't know.
So now it's on that number.
We didn't get any feedback after we tipped it.
Not that she
Tip
wasn't.
tip it back up, Fred. Point it back up again. Still nothing happening, is there? Go ahead.
No, nothing.
What the hell?
Yeah. Okay.
Thanks, no problem.
So what's on?
Hello.
We also have synchrony versus legs. Navigate and Greenblatt are on those.
Give me a minute, Joe, and we'll bring him in.
Yeah, because if I can stand here and I can yell this loud into it, and we're still not getting. I
Yeah,
know.
that's weird. Yeah,
So you figured louder would mean it would actually do it.
you would think. Yeah. Thanks, Fred.
Hello? Yeah.
All right, attorneys on Synchrony Bank versus Legs, please.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record.
Mr. Greenblatt, you with us? Mr. Greenblatt, you there? Mr. Greenblatt, you there?
I'm chatting to him right now.
Mr. Stevens, are you connected?
Good morning, Your Honor.
Good morning, Mr. Stevens. I'm gonna put
Can
you
you
on
see?
mute and I'm gonna leave you right where you're at for a minute while we take care of another matter. If you can figure out how to get your video camera turned on, please do so.
Okay.
Mr. Greenblatt, are you with me?
Yes, Judge.
There you go. Your appearance on behalf of Synchrony Bank versus Legs.
Actually, my appearance is on behalf of Elizabeth Leggs, Philip A. Greenblatt, P54170.
You have filed a motion to withdraw, correct?
Correct, Judge.
All right. Ms. Francis, any response?
No objection, Your Honor.
All right. Mr. Greenblatt, did you have any conversation with Ms. Legs about today's hearings that was scheduled?
I have sent her multiple emails and texts indicating my firm's intention to withdraw for lack of cooperation in this matter. The proposed, and I have not received a reply from her. The proposed order reflects that she is to either, with the court's permission, allow me to withdraw and require her to either represent herself immediately or with the court's discretion, if the court so chooses, to give her a specified amount of time to retain new counsel.
All right. So counsel, what I'll do, Ms. Francis, I'm gonna have the civil department send out a notice for a pretrial.
Yes, Your Honor.
And actually, Mr. Greenblatt, why don't you stick around for a minute? Sandy's gonna send you a date, so you'll know when that new pretrial is, and in your order, you can draft the order such that she's gotta be prepared to represent herself or have a new attorney by that date.
There's already attached proposed order to the motion that indicates the time slot that could
okay.
just be
Yeah, I
handwritten
see it.
in.
Actually, no, I don't have an order,
It should be the last page.
usually, but it's not.
Would you like me to email one or fax it to the court?
Yeah, email that to Sandy so we can get this entered and we'll get another pretrial on the books. Ms. Francis, is that agreeable?
Yes, Your Honor.
All right, thank you, folks.
I just need Sandy's email, or I'll call the
All right,
court.
Yeah, great, thank you.
Thank
I
you,
just
Judge.
chatted to him.
Thank you.
Sandy just sent it to you, Mr. Greenblatt.
Thank you, Judge.
Thank you.
You two have a good afternoon.
You too.
All right, Mr. Stevens, we're bringing Mr. Sweets into the courtroom so we can get started. Have a seat. All right, are you on? All right. Calling the case of Matthew Sweets versus Stephen Stevens. Mr. Sweets, good morning. Morning. Still morning. We've got Mr.
Good morning.
Stevens
Good
on
morning, Your Honor.
Zoom. Mr. Stevens, could you hear Mr. Sweets when he talked?
Yes, sir.
Okay, all right. And Mr. Sweets, you're ready to go forward today?
Yeah.
And Mr. Stevens, you're ready to for the hearing?
Yes, sir.
Okay, all right, so I think I told you guys last time we had you, the rules. One person talks at a time,
you said
say with the yes,
Yep.
I was probably gonna interrupt you. We went over all that.
I remember everything. you
Mr.
said.
Stevens, correct? We went
Yes,
over all
sir.
that? Okay.
Yes, sir.
All right, so I brought you in live because it sounded like we were gonna get into some visual evidence, so on and so forth. So I'm gonna turn it over to Mr. Sweets. Mr. Sweets, this is your opportunity to convince the court that A, Mr. Stevens owes you money, and B, how much money he owes you.
Gotcha.
Understood? So go ahead and get started.
Can I give you the pictures?
Sure, sure.
Those are the pictures of my driveway.
All right, so Mr. Stevens, Mr. Sweets is handing me some photographs. Any objections if I look at those?
No problem.
All right. I don't know if there's any way I can show you these, but let's see how good my powers of description are.
Some of the pictures are before and after. I kind of wrote on the picture, stating
Yeah, let me find. Yeah, before,
yeah.
after. So we've got two that are marked before and after. I'm assuming the two that are showing what I'd say are cracks are after
That's the
photos.
concrete. That's, yep. That's
Is,
what I said.
is that the same area?
Same, yes. that's
Two
the
different
same.
views?
Yes, correct.
All right.
Yep. So basically, it's simple.
All right, hold on. Let me, I'm gonna try to describe to him what I've got in front of me.
Oh, okay.
So the first thing I've got, Mr. Stevens, is a before photo that I assume is a view taken from the garage or the house where there's some existing concrete. Concrete looks like a paved walkway up towards the house. I can see a little bit of a wooden stair rail, and it's looking out to the street where there's what appears to be a gravel or chip seal driveway.
Gravel.
Okay. That's the first photo I'm looking at, Mr. Stevens. And then I'm looking at a photo that's marked after that is, I would say, like a close-up photo of the end of the driveway where it meets the road. Would you agree with me?
Correct. That's after he scraped.
Okay.
So all he did was scrape it.
Okay. And then I've got a photo that's labeled 10 by 10 he made, and that's a chunk of concrete that Mr. Stevens' company poured.
It broke it. His excavator broke it.
All right. And then I've got one with a van here. What's this photo of?
That's the back little.
This is
where my van is parked. That's where another little section of the driveway where he scraped.
Okay, so this concrete was existing
Oh
concrete.
yeah. It's just
Right.
he was
Right.
gonna put asphalt down, so he scraped
Okay.
the existing driveway,
Right.
which was
Right.
gravel mixed with
Right, and then
millings.
the
asphalt millings.
what I'm looking at here, look a crack in the
That's the piece he
concrete.
broke off with the excavator.
Okay, all right. So now I think you have an idea what I've looked at for photos, correct, Mr. Stevens?
I'm correct. Yes.
Give me just a minute, gentlemen. I'm trying to deal with a city hall issue. All right, go ahead, sir.
So it was 3,500. The agreement was 3,500 to do asphalt on the pictures I shown you on my driveway. He came there.
Now let me stop you. I told you I was gonna interrupt you. So the photo I'm looking at, which is the first one I described to Mr. Stevens, where it shows the wooden railing for the house, so on and so forth, was agreement to pay from the concrete that I'm seeing to the street?
Correct.
Okay, go ahead. I just want to make sure the scope was clear.
For sure. So he was gonna do the asphalt for 3,500 to do that front and then the back section. And then do a little 10 by 10. You have the picture. He cut in a 10 by 10 spot for a parking spot to do asphalt also. 3,500 for the job. He came there for like two hours and scraped it and cut in that little 10 by 10 parking spot. And that was it. And I gave him $2,000. And for two hours just to scrape, I don't think that's worth 2,000. And why I'm here. That's why I'm here. Plus the concrete, 1,500, 2,000 plus 1,500 for my time. And that's it, $5,000.
All right, so you paid 2,000.
Yeah.
And then what's the balance of your claim?
5,000 total.
And where are you coming up with the 3,000?
I thought the 2,000 that I paid him.
Right.
1,500 for the broke concrete. That's 35.
All right,
And
how,
15
hold on, how are you come up with the 1,500 for the concrete?
I just did. I just came up with it with my past knowledge of concrete.
Okay,
expense.
well, explain it to me. Because
Explain
right now, pulling it out of the air doesn't give me.
Well,
one.
concrete's very expensive. They charge about $1,000 for for a little pad, a little 5x5.
So you haven't gotten any quotes or anything from anybody?
No quotes, no, but I know all about it. I've been in construction for 30 years.
Well, brother, you better do a better job explaining your knowledge then, because it's real expensive. They charge 5,000 for 5 square feet. That doesn't get me where I need to be.
No. It's 2,000 for what I paid him. I want the 2,000 back.
I understand that. And you also want $3,000 for this broken concrete.
No, 1,500 for that. 1,500
Okay.
for the concrete patch. 1,500 for the concrete.
So
1,500 for my time. 2,000 for the money I paid.
what's 1,500 for your time? What time?
Just the time involved.
Doing what?
That's what I'm suing for. That's plain and simple.
For coming to court today?
No.
Then what time?
For
I don't
dealing with
understand.
everything, just for that, that's $1,500.
All right, so you want $1,500 for pain and suffering?
Just everything involved, correct?
Okay, that's not gonna happen.
I mean, that's up to you.
Yeah.
I'm just telling you what
Yeah.
it was for. I don't, you keep questioning
Okay,
about it.
all right, so the $1,500.
I mean, that's up to you. I mean, you're the judge.
Yeah.
You gotta decide what.
All right, I don't need you to give me my authority.
But
all
you're
right?
just
Hold
confused.
on, hold on. I'm still hung up on this.
Okay.
There's a busted piece of concrete, like
Correct.
a triangle shape, right?
Correct.
So how much
I'm
concrete
sorry.
are you gonna
I'm sorry, let me
repaint?
explain that. You can't just fix like a piece of concrete. You gotta do the whole section, and the section's 10 by 10. I'm sorry. Yeah, so you can't just fix a piece. You gotta fix like the whole, you gotta cut out the whole thing. Yeah, so that's how.
So the $1,500 is for 10 square feet of concrete.
Correct.
Okay,
Correct.
all right.
Yeah, sorry, I didn't explain that well. You can't just fix a little piece. You gotta do the whole section, sorry. Yeah, that's why it's so expensive.
All right, Mr. Stevens, do you have any questions for Mr. Sweets?
No, that's his testimony, and I'm just waiting my turn.
Okay, all right, so clarification. Mr. Stevens or his crew came in and did some prep work, but they didn't bring any material in?
No material.
Okay, all right, anything else from you at this point?
No, just hopefully you got everything.
All right.
If hope you all understood everything very
All right.
good. I'm not very good at explaining things,
Okay.
obviously.
No other witnesses, correct?
No witness.
Okay, all right, Mr. Stevens, your turn.
Good morning, Your Honor. First of all, I'd like to say that I believe last time when we were in court, you swore me in, so I take that seriously, by the way. And I was contacted by Mr. Sweet on a little asphalt project. And if you notice on the heading of my paperwork, it says affordable cement. And so I do cement work for many years. So when I got there, we agreed upon a price, and I brought I believe he stated I brought some kind of backhoe or some kind of excavator machine in that busted his concrete. What I brought in was a mini skid loader that doesn't even weigh as much as his SUV. I worked with concrete for many years. I know just how to go around about working with concrete. And we got in the back area that day. We excavated out the back end. We removed a pile of asphalt, recycled asphalt product, about 10 yards. We got in the front
Okay,
area.
hold on. I didn't understand what you said. You said you came in and you did some work in the back area. Is that the parking spot that Mr. Sweets referred to?
No, where the van is.
It's the back area beside where the back parking area of the garage, and it goes around the back side of the garage.
All right.
We started there first. We removed and prepped the whole entire area, which included moving about 10 yards of recycled asphalt. Now, at that point, we moved to the front. We excavated out the parking area that he wanted, additional parking area of new construction was grass, and we put the debris and dirt in a low-lying area adjacent to the parking area, which would stop the water from settling there and coming up against the cement. And then we moved the pile of debris of recycled asphalt as a base layer, which is more than sufficient for base for parking a van on a small pad. We put that in the area and leveled it out. Then we moved to the.
Let me stop you again. So you said you removed about 10 yards of recycled asphalt from the back, correct?
Yes, sir.
Okay, now you're telling me you put that same 10 yards down in another spot?
Yeah, because he had too much. It was just overages. This is what he had on his entire area. We use it often. We all use it. It is base layer. And he just had too much. And that's why it was piled back there. So to keep it affordable for him, and to still follow asphalt pavers requirements, we use that for a base layer, which was a savings to him up to about $500. And we're trying to keep it in his budget, yet do him a first-class job. And all he was parking on it was his vehicle, nothing heavy, a small area parking. It was more than sufficient for the depth that I went. I didn't go 4 inches, I went about 8 inches. So I surpassed the double. And we used that, which was good. And we turned around, went to the front existing driveway and prepped that and edged it and dug footings along all the cement and along the front driveway. And I told Mr. Sweet at that point, we will be back in the morning. See, this was initial day, we move-in day. We were there about approximately close to 4.5 hours. It was getting late. And I told him we'll be back in the morning to do the finished prep work and to pressure wash and
Do not
cement.
interrupt him again. Mr. Stevens, you said that you dug footings for the driveway?
I dug footings around the whole structure. Yes, I did.
Okay, what structure?
Around a cement structure in front of the garage structure and along the edges of the existing.
Hold on a minute. What you're calling structure, I would call the approach to the garage or the driveway that's there. Would you agree with me? It's like existing concrete.
Exactly.
Okay, so you dug a footing under the edge of that existing concrete? I'm trying to understand what you did.
Yeah, in front, you must, because whatever you're putting down must be thicker than your existing, for the simple reason we get so cold here, it begins to heave. It'll heave on you and separate.
Okay.
So it has to be
So
thicker.
when you use the word footing, to me, a footing means you're going down below frost. So I'm assuming you didn't go 42 inches with a footing for a driveway.
No, footing for driveway is 6 to 8 inches.
All right.
It's a driveway footing.
How wide was that 6 to 8 inches?
It would be approximately from 4 to 6 inches. I went about 6 inches.
All right. So basically you dug a 6x6 hole that was going to lead into this new asphalt driveway you were putting in.
Yeah, then when you put the new asphalt in, it's thicker around all the existing structure.
Okay, I got you. I wanted to understand.
And so now we moved to the front existing driveway and did the same with both edges of the existing driveway going out to the road, so that when it's resurfaced, you have a thicker amount of asphalt on the edges so it doesn't crack off. Now, that was day 2 comes along. Now on day 1, I'm ahead of my story. Mr. Sweet kind of has a little bit of an attitude. He's worried about his concrete. He didn't like the fact that I was driving across his concrete nor putting product on his concrete. I assured him that, we work concrete. Once we pressure wash your concrete, you'll see it'll be like better than new because your concrete's dirty. I said that doesn't come till tomorrow, the next day. So we showed up the next morning, Mr. Sweet, and we didn't show up that early. It was about probably 9:30, 10 a.m. His vehicle's parked right on our work area. So him knowing that we're coming, I beat on the door. He's not answering the door. Now there's a Jason window there. I beat him on the door for at least 8 to 10 minutes. I beat on the window a couple of times. Here he comes out. He just looked like he fresh got out of bed. We're noticing in the yard, it's full beer cans. I said, oh Lord, I don't know what happened last night here. He came out and he said, this is a good way to get shot. I said, really? I said, we're here to do your job, sir. Could you please move your RV? So he went back in the house. He didn't come out for at least 30 minutes. And we're working around the RV. He came out really upset, and all he had to do was pull it up 10 feet. He could have did that while he was there. He didn't. He came out. He looked about the same way. Don't look like he cleaned up. He went back, pulled the vehicle up 10 feet, went back in the house. Now we pressure washed the whole entire area, finished up the footings, cleaned up the second day, and now we're going to do final inspection with Mr. Sweet because we don't want any issues. I know about concrete. I know about issues that we don't want the day that we're pouring. So when he came back out, he wants an even wider radius around the new area that we are going to put in for his vehicle along the front of his garage.
Let me stop you. He wanted what kind of radius?
A radius so he makes sure that he doesn't pull on the grass. So I seen what kind of person he was, sir, and not to get on his bad side. I made it 5 inches wider than what we agreed on, but we had to go from an inch to a half an inch even wider. So now I'm not really paying attention to the guys, even though I gave him a heads up. Look, don't mess with this guy. He seems like you get easy attitude. I worked for people like this before. It's no big deal. We're professionals. Let's just be calm and do our job. Now, after day 2, when we got it all completed, the monies that I got paid, Your Honor, was for the work that we got completed. I was going to use that monies also to pay for the asphalt products and then recoup my first day money off of the balance that was owed to me. But at that point, my guys are telling me about what Mr. Sweet and how he's talking to them and how rude he's talking, and he's still keeping up his attitude. I was hoping that would get better as the day went by. And so the very next day, now 2 days, I left the second day, pressure washed, clean, no cracks, no problems. I goes home, my guys goes home. On day 3, I called Mr. Sweet. I said, Mr. Sweet, I'm trying to fill him out over the phone. You know, we want to finish your job. He starts up a little bit. I said, hold it right there, sir. We're not going to put ourselves in jeopardy. I didn't like your attitude. We don't like to be threatened. You have more than enough money to do. We did the heavy lifting. We did all the work. We did all the prep work. The actual asphalt work is the easy part. And so he had plenty enough money to do what he had to do. I said, you find somebody else to finish your work. We're not coming back on your job. And so I refused to come back on that job. We didn't get no gratitude of our professionalism, nor did he even, it's always complaining. And the guy's just too jittery. And then he's going to turn around and tell us a good way to get shot. I mean, you know, just it's so bad out there these days, Your Honor. We don't want to put ourselves in that kind of situation. We got paid for what we've done. We did more work the first 2 days than what it would have took the third day to pay. I would have made way more profit. I could have knocked out 2 little jobs like that in the same day. And so, I mean, actually, we took a loss on a job. And as far as that crack's concerned, I don't know where he came up with a crack. The only thing I can figure is if a paving company is not vigilant to cement driving a heavy paver machine with product across it, you can crack cement. And so that is left up in the air. There's no way I can prove that. And so here we are with him having a crack with a 5x5 area, which I would charge maximum all the way from Belleville to Detroit to do a repair area, saw cut repair area that size for $500 all the way to Detroit. And so I don't know where he's coming up with the whole area has to be removed. Apparently he's not a concrete man and doesn't know the first thing about concrete. But we're in a situation here where he says, I went out there for a couple hours and stole his money. I have no record of that, of ever doing that to anyone. I've even done work for 34th District Court, the parking lot out there. Everyone knows me. I mean, I am not a person that goes around ripping and tearing people off. We went out of our way to do an expensive, perfect job, above and beyond what we're supposed to do. And the reason why we didn't come back the third day is because I didn't like his attitude, and I'm not going to be threatened. That's the bottom line.
All right, let me ask you a question. You said that you put in about 4.5 hours on day one, correct?
Well, actual labor, yes, but from the time we were on the job and waiting for the skid loader and to show up and the tool truck to show up, we were out there about 6.5, 7 hours, but we actually put 4.5 hours for labor the first day and about 5 hours the second day.
All right, so on day one, you had a skid steer and how many men?
Beg your pardon?
On day one, you had a skid steer and how many men?
3 men.
Day two, same equipment?
No, the skid steer, we were finished with the skid steer, a 3-man power washer and all hand work.
All right, so
The
3 men
skid steer-
again on day two?
Power washer, hand equipment, and 3 men. My cost overall was a little under $1,300 for everything. Skid steer was rental from Wolverine Rental, with delivery and pickup and skid steer rental was right at $783.
All right, so you said your costs were about $1,300 and that was for the skid steer and what else?
And for my men for the two times they were out there.
Wages.
Beg pardon?
For wages, what you paid your help?
Yeah. Well, my guys don't get paid hourly. That's not the way we actually do this. It's very hard labor. So if it leads into a half a day, they get a half a day. If it leads into a full day and they're a couple days short, I still give a full day. So to get anywhere from
I'm trying to
150.
clarify. You said your costs for day one and two was about $1,300. That's the rental and what your labor cost you.
Exactly.
Okay. All right. Anything else at this point, Mr. Stevens?
No, sir, Your Honor.
Mr. Sweets, do you have any questions for Mr. Stevens?
Why is he lying?
Well, get a better question than that.
I mean, he's lying about everything.
That's not a question. Do you have any questions for Mr. Stevens?
I mean,
Yes or no? Do you have any questions for Mr. Stevens?
why are you doing this to me? Why are you ripping people off?
All right. Counterproductive, sir.
I don't know.
I'm here as a trier of fact. All right.
Just
If you have a question,
I'm sorry, my mind is blown right now. I'm sorry.
well, then take your blown mind and leave if you can't play by my rules.
I'm listening.
All right. Do you have a legitimate question for him about the facts?
Yes. So you was only there for 2 hours. How did you get 4, 5, 6, 7, or 7 hours you was there? And also your men.
Okay, one question at a time.
Okay, yeah. Your hours is way off.
That wasn't a question.
How did you come up with 7 hours? You was only there for 2 hours and worked for 2 hours.
Mr. Stevens?
To be honest with you, Judge, and no disrespect to Mr. Sweet, he was in such a state of mind, the man would only come out once in a while to us. He wasn't there on top of seeing and count the time we was there. I have to count the time. That's what I do, sir. There's no reason to even lie. You know, there's no reason to lie, even if it was 2 hours. Let's put it in his perspective. If it was 2 hours one day and 2 hours another day, that's the price that I get for prepping a job. And so that's why I got paid that. But I did not. I was there longer. And, you know, it just my word, my good standing against his word, his good standing. And I mean, I have people who would verify exactly what's going on and witnesses to the fact, but unfortunately, I can't get them at this point. But here we are. It's my word against his word. And so it's all left up to your hands.
Any other questions for Mr. Stevens?
You know, why did you bring 3 guys and only one guy did like 20 minutes of work and the other guys were passing out, like looked like they were on heroin? One guy wanted to fall asleep in your car.
Right,
and
sir,
they're
sir,
drinking
do you
beer.
understand what a question is?
I'm
I'm asking you for a question and you're making statements.
I'm asking him why he brought 3 guys and only one guy worked for like 20 minutes.
All right, you're not making this easier on
I'm
yourself,
sorry.
okay?
I don't know.
You want to argue with him, and the time for you guys to settle this was before you got to me.
Okay.
I'm not going to allow you to argue with him.
I'm
You've
not
heard his testimony. He says he had 3 guys there and they worked for 4.5 days on day one. So for you to come back and say, why were 2 of them sleeping? Seriously,
Well, he's just not telling the truth. I don't know
All
what
right,
else.
well, that's a different issue. You can disagree with his facts.
Okay. I disagree with his facts.
All right. So where is this at? Because this close-up picture doesn't let me place it anywhere on your
Right
job
to
site.
that little parking spot he cut it. Because, so when he cut it down.
So back here by the van?
No, the other spot. There's another picture of the pad. There's another picture.
This one?
I think that's it. Yep, that's it.
So where is that busted truck?
Right there. Yep, right there. Yep. It's right there. And, so when he dug down the footing he
So
called.
hold on a minute. So this is the piece. Is that a separate piece of concrete like this? Like a long triangle and piece
Yeah.
that's busted off?
Yeah.
So you'd have to replace this, correct?
Like the whole pad or whatever, yeah.
Which is nowhere near 5 square feet.
The whole.
This whole thing?
Yes, correct.
There's a saw cut or something here. That looks like a joint to me.
So when he cut down 8 inches for the footing, that's what, when he wrote drilled.
Is this a joint?
Yeah, I'm not,
How do you know? What do you mean you're not sure?
I think he's got to cut up the whole pad to redo it. So I'm just explaining when.
All right, but you have no quotes from anybody. For your $1,500, you didn't get a contractor come out there and say, hey, how much to fix this busted spot?
I did not.
All right, when was that spot, when was that little triangle busted? Day one or day
I
two?
was about to explain to you, when he dug the fitting, when he dug the footing, like 6 to 8 inches, that's what kind of broke it. So when he drove the escalate, when he drove it over it, it broke the piece off, because when he dug down, here's the concrete.
Okay, my question was day one or day two? When did that piece get broken?
Day one.
Okay, all right. So did you walk the job site with Mr. Stevens at the end of day one?
No.
At any point, did you walk the job site with Mr. Stevens after they showed up to do work?
I was out there when they were working.
Is that a no?
What's the question?
At any time, did you walk the job site with Mr. Stevens to talk about progress or what was the next step or anything like that?
Yes.
Okay. Day one or day two?
Day one.
Okay. Did you have any conversation with Mr. Stevens on day two?
No.
Not at all?
They came for like 20 minutes and I think they power washed real quick and left.
Okay. So you didn't talk to Mr. Stevens at all on day two?
No.
So you didn't have a conversation about
He
moving?
wouldn't answer the phone. He wouldn't answer. No, I did. I meant to answer your question, sir. I did not talk to him.
So there was no conversation with you and Mr. Stevens about moving your RV?
No.
Okay. So he didn't have to get you out of the house to move an RV on day two?
Day two or day one?
His testimony was day two.
I'm trying to think. It's so long ago. Day two. You know what? I think day two, yes. Okay, day two, he banged on my window.
Okay, so when you came out of the house and you talked to Mr. Stevens, did you at that point say, hey, I got a busted piece of concrete from yesterday?
I did not notice it. I didn't notice it until like a couple days later.
Then how do you know it was done on day one?
Because it wasn't there before.
Couldn't it have been done on day two?
No, because they didn't have the excavator. They only had that. He only had the excavator on day one.
Okay.
He just rented it for like an hour.
Okay. All right. Anything else?
No.
Mr. Stevens, anything else?
Well, sir, I just want to reiterate on day two, after we pressure washed the whole entire concrete and the existing driveway because they were dirt on it because we dug footings along the edge of the asphalt driveway. We did a total walkover of the whole entire surface in which he had me dig the radius on the parking area an inch wider, being a real stickler, in which I was 3 inches over. I informed him, I'm 3 inches wider than what you wanted it. I had to get the guys, get the tools back out of the tool truck and dig it 1 inch wider for him on day two.
All right, anything else?
That's it, sir.
All right. Did Mr. Stevens' crew move any material from the back to the front?
Yeah. I had material that I had in cuts, so he didn't have to buy any. Because I had some material when he cut in the 10 by 10 parking spot. I had him put the material in the parking spot, so he didn't have to get any material.
All right. So after Mr. Stevens' crew was gone on day number two, did you ever get this paved?
I did.
All right. Asphalt or concrete?
Asphalt.
All right. And did that asphalt company come in and just put asphalt down on what Mr. Stevens had done, or did they come in and do more work?
More work. They had to prep it. They had to re-prep it. He did
What-
it all wrong.
All right, just explain that. How was it wrong?
He didn't do the footings right.
What was wrong about him? Give me specifics.
He just didn't cut them in deep enough.
Okay, so,
Basically not deep enough.
all right, so the new crew dug them up to see that they were too shallow?
Correct. Correct.
Right. And how deep were they?
They're a couple inches. They gotta be like 7 inches or something.
All right. And what did the follow-up job cost you?
I think it was 3,500.
You don't have any paperwork on that?
I didn't bring the new paperwork with the new. I didn't bring the new paperwork with my.
Right. Was the new paperwork from contractor number 2, was that specific enough to show how much of the 35 was prep work and how much was paving?
No, he didn't itemize it. He didn't itemize it up. No.
All right.
Heck, I don't even think he gave me paperwork.
The new contractor did.
Yeah.
All right. Anything else?
No.
Mr. Stevens, anything else from you?
At this point, Your Honor, it would just be my word against his word. It's up to you to make a decision. I just want to reiterate, everything I told you was factual from my end.
Thank you. I'm finding no cause of action, Mr. Sweets. I will have the civil department prepare a judgment if you'd like one for your records. Thank you, gentlemen.
Can I say one?
Thank you.
If it'll make you feel better.
I just want this guy off the streets because he's been ripping a lot of people off. And
Well, you
the
didn't.
gentleman-
Thank you,
You
Your
didn't
Honor.
prove
You
it
have a
up to
great
us.
day.
The gentleman.
Good luck with your wife, Mr. Stevens.
The gentleman that serves papers for you guys, that works for you guys, he knows all about this guy.
Okay, but
So does the guy out here that I talked to. They
which,
all know about him.
none of which matters to
I
the
just want him
case.
off the street, that's all.
None of which matters to the case you
Breaking
brought.
the law.
Have a nice day.
Yeah, for sure.
Hey, Joe, you mind taking some stuff down to Sandy?
Not at all.
Thanks. Thank you much. Till 1:30.
I'm sure.
That's what I was thinking whenever, okay.
Sandy? Sandy. Hmm? Sandy.
Hello.
Ms. Harris, what are you calling in for?
Okay, I'm sorry if you're busy. I'm sorry, I really do. But I just looked at my paper. I'm sorry, I checked my mail late, and it said that I had a court date for the 12 at 1:30.
January 12th?
Yes.
I can't help you.
Um.
Go to our website. Go to our website under contact us, and you can send us an email and tell us what's going on so we can reschedule you.
Okay, thank you so much.
Good luck.
Thank you.
Sandy, are you on? You know, usually this thing down here, I can click and it gives me the option to deal with it. It says it's live on YouTube.
It does. Click on that right
Well, I
there.
did,
And what does that take us to? You
but it doesn't give me the option of
How about
pausing
you
it.
hit that button right there?
This,
Yeah.
stop recording. No.
Let's stop recording first. So say yes. Let's see if that gets us in. Okay, now go in there. Let's start from there. All right, let me see. Go into apps. Is it one of our, it is an app, isn't it?
I think the problem is I'm not a host or co-host.
Oh, who's the host?
These two, I think.
Oh, that's why. That is why we don't have options.